Nomi's holder of the Nathan and Lily Chappell Chair in Law at USC, and she is at work on a book on liberalism and religion in American law and culture. And her paper for us today is entitled Grounding Kiryas Yoel. Nomi.
Thank you. Can you hear me? Yeah, okay. I also really want to express my gratitude to Mark and Suzanne. If I had more time, I could say more, but really both the first conference and this have been really important in my own autobiography. What I wanted to talk about today is the Jewish impact on American law seen through the lens of Kiryas Yoel. The more ambitious version of this talk plan to talk both about the Jewish impact on American law, but also the impact of American law and culture on a Jewish community that I think is well illustrated in the case of Kiryas Yoel. But time is short, and I'm probably not going to have time to say much about the latter topic, the impact of American law on Kiryas Yoel. But I do want to mention it, if only to say that I think one really can't say very much at all about the Jewish impact on American law without really seeing that there's an interplay here between Jewish and American culture, between Jewish and American legal systems. So the fuller story would really deal with both sides of that equation. When I'm talking about Kiryas Yoel, my comments today are not focusing on the most well-known case of Kiryas Yoel, which we heard about yesterday with regard to Nathan Lewin's involvement in arguing the case that came out of Kiryas Yoel went up to the Supreme Court challenging the constitutionality of the public school district that was established in the homogeneous, entirely Satmar community of Kiryas Yoel. I'm actually talking about the other Kiryas Yoel. The other case are actually really a messy spawn of cases that have been generated subsequent to that Supreme Court case, all of which arise out of this known, I'm sure, to many of you, particularly those in the New York area, but not exclusively, very, very acrimonious, messy, bloody battle, succession battle between two sons of the recently deceased Rebbe, Grand Rebbe of Kiryas Yoel. Moshe died recently, and his sons Zalman and Aaron have been locked in a bitter dispute, going far beyond them. So the followers of Zalman, the Zalis, the followers of Aaron, the younger son, the Aronis, have generated absolutely fascinating, I wish I had time to describe it, I don't, to just condense all the fascinating complexities and shenanigans. I think one could describe, I think the best word is antic to describe this litigation. So I don't have time to describe the litigation in any detail. To make a long story short, what I do want to try to do is summarize as the Zali's legal theory and the Aronis legal theory, that the same legal theory expressed in these various cases, and then see what we can unpack from them. So the Zali's legal theory, they have a story to tell. I'll make the long story as short as I can, condensed to its essence. In 1999, the Grand Rebbe Moshe, who is the heir to the original Rebbe, Yoel Teitelbaum, names his son Zalman to be the chief rabbi of the Williamsburg congregation, which is understood by everyone, say the Zalis, to also at the same time be an anointment of Zalman as the heir, as the future heir, and there's a kunsis, a document in which this understanding is supposedly memorialized. This precipitated a rebellion by the followers of the younger son Aaron, the chief rabbi of Kiryas Yoel, the Aronis. Chief among them, one Beryl Friedman, at the time was co-president of the Satmar congregation. And one of the interesting things, for my purposes, is that the Satmars actually are organized as a private corporation under state corporation laws, in particular the New York nonprofit corporation law, religious corporation law. And in conformity with these laws, they long ago adopted bylaws, which, among other things, provide for the election of a board of directors and specify other details of corporate governance. The story goes on. The Aroni rebels, led by Friedman, engineered a coup, say the Zalis. And this involves both the calling and then the actual holding of elections by Friedman, which, surprise, surprise, result in his putative election as president. And this is understood as an attempt to oust the other previous co-president, who was a Zali. And at the same time, or roughly around the same time, that Friedman calls for this new election of a new board of directors of the corporation. He also executes a deed transferring title to the cemetery in Kiryas, an extremely important property asset. So he engages in all of these activities, which the Zalis respond to, and they allege that the still living Rebbe responds to by removing Friedman from the board of directors, by expelling him from the congregation. He's no longer a member of the Satmar congregation at all. He's subject to condemnation by a rabbinic court. And then the Zalis hold their own elections, which equally surprisingly result in the election of a Zali as putative president. So it's at this point that the legal action begins. The Aronis, including Friedman, go to court. And like I said, lots of different litigations, but in essence what they're doing is A, challenging the validity of the Zali elections under state corporation laws, which govern how elections are to be held and how removals are to take place, and also seeking a declaration of the validity of the deed. So Zali's legal theory in a nutshell boils down to this. Number one, Friedman had no legal authority to call the elections, to transfer the property, anything. Why? Because the Grand Rebbe had ordered his removal and expulsion. So he didn't have any authority. He was no longer in the position of president of the board. How did the Grand Rebbe have the authority to do this? The Grand Rebbe had the authority to execute his removal and expulsion, even though the bylaws on the face of them might appear not to grant the Rebbe this authority. Why? Because, and here we're getting into issues that were alluded to in comments yesterday, because the Grand Rebbe's authority is unlimited. It's what we might think of, although none of the parties use this language, as the plenary power theory of the Grand Rebbe's authority. And what's key here and what I want to emphasize is that in this theory, there is no distinction to be drawn between secular and spiritual matters, or secular and religious jurisdictions. There's a denial of the existence of any such distinction in Satmar understandings of Jewish law. So in this respect, the Satmar conception as represented by the Zalis is quite clearly unlike secular law, which, as we've a recurring theme, we draw a distinction between secular and spiritual realms expressed in the basic principle of the separation of church and state. But it's also, and I want to underscore this point, very unlike the traditional Orthodox conception. And here I'm very grateful to Suzanne for having made her comment yesterday about the traditional rabbinic conception of imperfect law. Which, and I wish I had time to elaborate, but I don't. I should just say simply what she said. But just to remind you all, she's referencing traditional rabbinic conception that law is inherently imperfect. If we were making the same point in a Christian idiom, we might talk about the inherently fallen nature of law. Therefore, it's sort of dirty work, but someone's got to do it theory, the dirty work theory of secular state and secular law. But what's key here is that there's a religious justification of the need for secular law and the need to maintain the separation, to recognize a distinction between spiritual and secular matters, and to maintain the separation between these two jurisdictions. That is a traditional rabbinic conception, which supposedly is rejected by the Satmars.